in case number 22CRI027. This is in the state of Ohio, plaintiff versus Jeffrey Fry. Defendant, we're conducting this hearing via Zoom video conferencing. This matters before the court today for purposes of sentencing. The defendant previously had entered pleas of guilty to count 1 in the indictment as amended, as well as count 3 in the indictment. Present on behalf of the state of Ohio is Assistant Prosecuting Attorney Mike Callow. Also present on behalf of the defendant is Attorney James Mayer. Mr. Fry is also appearing. He is on site of the courthouse and he is appearing from the bailiff's office. Attorney Mayer, on behalf of your client and yourself, do you consent to conducting these proceedings via Zoom video conferencing?
Yes, Your Honor.
Okay. Assistant Prosecuting Attorney Callow, on behalf of the state of Ohio, do you consent to conducting these hearings via Zoom video conferencing?
Yes, Your Honor.
As alluded to in the court's comments, Attorney Mayer and Attorney Callow are present. Mr. Fry is present. The bailiff is logged in, and this judicial officer, there does not appear to be any other participants in our proceeding. As I indicated, we are here for purposes of sentencing. The court has received and has reviewed a pre-sentence investigation and report that was completed by investigating officer Zane Troop. The court has not received any victim impact information in this matter, although the court staff advised that the opportunity to provide that information or report to the court has been provided to the family of the victims in this case. Attorney Mayer, have you had an opportunity to review the pre-sentence investigation if you choose to?
Yes, Judge, I have had a chance to review it myself and also discuss it with my client here at the office last Friday.
Assistant Prosecuting Attorney Callow?
Yes, Your Honor, we have reviewed it. Thank you.
Thank you. Then Attorney Mayer, is there anything you'd like to say on behalf of your client for purposes of the court's consideration and sentencing today?
Yes, Judge, there is. As I'm sure you recall, this case pending for some time, given the fact that my client's previous retained counsel took another position. I took this case over somewhere in the middle. Ultimately was able to engage in extensive negotiations with both Mr. Callow and Mr. Tennell. Ultimately, those negotiations included conversations between the state and the victim's family, victims, of course, being minor children in this case. And the end result was the plea that we entered into a little while back, essentially to the offense, one of the ag vehicular assaults, but taking into consideration both victims and doing so as a stipulation, along with one of the OVIs for the 161 test. The end result being a joint recommended sentence between the parties for the 1-year minimum in this case. My client has understood from the get-go, at least during the time that I've been representing him, and being part of those discussions, that any plea to the charge would result in a prison sentence. And so he comes into this hearing with eyes wide open. He also entered into this agreement, understanding that this would be the state's recommendation. Judge, I think that the joint recommendation is appropriate in this case for several reasons, which I'll highlight. And Mr. Fry certainly hopes that you agree that the 1-year minimum is appropriate and that you impose that here today. Judge, he is 59 years old. He has been a productive, law-abiding member of the community. He's married for 29 years. He has 2 adult-age children, ages 29 and 27, and 1 grandchild. He's worked for the last 27 years without interruption at VCU Electric. He's relatively close to retirement. They've kept him on during the pendency of this case, and they intend to have him back once he serves his sentence. And I think that speaks to the type of person from a character standpoint, and also the type of employee is from a work ethic and skill standpoint. Judge, he was arraigned on January 19th of 2022. He was placed on pretrial supervision, as you would imagine he would have been at the time. It's my understanding he has presented absolutely no issues during the time that he's been on supervision. He has strictly complied with all terms and conditions, which we always hope is the case, but oftentimes it isn't. He freely admitted during the PSI process, he was open and honest, that he's someone who would drink from time to time prior to this happening. But he has maintained complete sobriety since the crash. He indicates he's not had a drink, and he doesn't intend to have one once he completes the sentence. It feels as though this was obviously a very serious crash, had serious injuries to children. He's thankful that the injuries were not long lasting, and certainly recognizes that things could have been far worse than they turned out to be. And he feels as though the best way to demonstrate for this court that he's taken it seriously and that there'll be no other acts similar is to just commit himself to complete sobriety. Judge, he does not have a criminal record that I noted in the PSI, nor during the time that I've met with him, with the exception, of course, of alcohol-related OVI offenses, albeit the last one in the 1990s. I believe, Judge, in his statement, in cooperating and being forthcoming, as noted by Mr. Troop throughout the PSI process, I believe that his statement demonstrated genuine remorse for his conduct, as well as acceptance of responsibility. I also noted that he scored out at a 6 on the risk assessment tool, firmly, neatly falling within the low risk to reoffend, and I suspect it would have been lower were it not for the alcohol in this case and the prior alcohol-related offenses. This is a person that never finds himself, in my opinion, in any court system playing the role of defendant if it weren't for alcohol. It's not blaming it on the alcohol, but it is an understanding on his part and a recognition that for him, there just can't be any drinking anymore. And I think that looking back over a period of what amounts to 20 months of sobriety, I think that's a fantastic indicator that once he finishes serving this sentence, that he will continue on with that sobriety. He looks forward to reuniting with his family upon his release. He looks forward to finishing out his career with VCU Electric and moving on toward retirement. He's obviously nervous, terrified at the prospect of going off to the prison, but he also understands that the law is the law, and he owned it by pleading, and he's prepared to accept the court's judgment today. We ask you to impose the joint sentence. Thank you.
Thank you. I'm gonna kind of do things maybe a little bit differently, and if anybody objects, they can. Mr. Fry, you're not required to make any statements here today. You have an attorney to do that. That's why you have one. That's why in part this case took so long, because we want to make sure that you had legal representation, and that's what you're entitled to. So he makes those statements on your behalf, but if there is anything that you would like to the court to know or consider before the court hears from the state of Ohio, the court would allow that. Is there anything you'd like the court to know or consider?
No, Your Honor.
No? Okay. All right. Attorney Callow, on behalf of the state of Ohio, is there anything you'd like the court to know or consider?
No, pursuant to the plea agreement, Judge, we would advocate for you to adopt the joint recommendation. Thank you.
All right. Well, as the court's indicated, the court has received a report completed by Mr. Troop. The court has reviewed that and will consider that. The court notes that included in that is some basic narrative details regarding this offense, that the court relies on, because that's the only information that's been presented to the court about this offense, and or you, Mr. Fry, as well as your prior history, outside of the fact that you have accepted responsibility for your actions by entering 2 pleas of guilty in this matter. So the court considers that and takes this situation, as do you, I have no doubt, very seriously. In sentencing you here today, the court considers, as the court always does, the purposes and principles of sentencing. Those include the overriding purposes to punish and rehabilitate you, to protect the public from future crime by you and others, using the minimum sanctions that the court determines is necessary for those purposes, without imposing an unnecessary burden on state or local government resources. The court also considers the principles of sentencing, considering the need for incapacitation, deterrence, and restitution. Now, in this case, the court has not received a request for restitution on behalf of the victims or by the victims, but the court would consider that had it been made. The court finds and knows that the sentence should always be commensurate to and with, and not demeaning to, the seriousness of your conduct and its impact on the victim. And the sentence should be consistent with sentences for other crimes of similar offenders. And the court will not and does not sentence you based upon your race, ethnicity, gender, or religion. And in those fashion, or in considering those things, the court considers further factors in this case, and weighs those specifically factors with regard to seriousness. In this case, the court would find that there are factors that would indicate that this conduct was more serious, that being that the victims in this case were 2 small children. Count 1 as amended was amended for purposes of incorporating both children, a 7 and a 5-year-old, into the conduct that the court could consider as it's making a determination of how to sentence you in this case. And so this is not just one individual, this is 2 individuals, and these are 2 long children, hopefully with long lives ahead of them, who at 7 and 5 are fairly fragile. I don't think I paid close enough attention in the PSI to see if you have your own children, but perhaps you can imagine if you do have nieces or nephews or your own children at 7 and 5, what an impactful event getting smashed on the road at night by a drunk driver would have on that child in that moment, and in their moments going forward, every time they're simply going about their business of going to grandma's, or helping mom and dad work, or wherever it is that they've got to go, they get to count on and reflect upon that circumstance that you've created for them back in 2021. The court finds there are factors that would constitute finding that this is a more serious offense. There are no factors that would cause the court to find that this is a less serious offense. And in fact, although the less serious and more serious factors under the law aren't simply a mirror of each other, the court would find that with regard to those seriousness factors, these victims didn't do anything to facilitate this offense. They're children, minding their own business, obeying the law, doing what all of us are entitled to do, which is move about. And when we take an operator's license as a driver, we abide by, and we're getting that privilege to operate a motor vehicle on the premise that we can all enjoy the freedom of travel because other people are going to follow the laws. And when they follow the laws, we're probably going to be safe. And you obliterate that when you go out onto the road under the influence. You didn't act under provocation. These were little children or passenger in a buggy. No one required you to consume alcohol. There's no reason that has been presented that you had to hurry and rush home, or you couldn't wait or have a driver to come get you. It's not reasonable to think that when we get in the car intoxicated and under the influence that we're not going to hurt somebody. ourselves, our passenger, other people, or their property. That's explicit in drinking and driving. The court hasn't heard any grounds for mitigation. Mr. Fry noted in the report writer's commentary, and I heard your attorney say it today, that you expressed genuine remorse. I missed that in the PSI, except for your words that say, there's not a day that goes by that I don't think about what I have done. I was hoping today maybe you might tell me what it is that you reflect on, because I think that you're tending to reflect more on your circumstances than what your conduct caused. So the court does find that there are no factors that would indicate that this is less serious. The court does find that.
Judge, if I may, I hate to interrupt, but on that point, my client prepared comments for today. I'm not certain if he wasn't understanding that that was the time to speak or not, but I know that he prepared comments today that spoke to that. That's the best I could say. I'm not sitting next to him to ask him why he didn't use that opportunity to speak. Perhaps he could comment on that if you wanted to hear his explanation as to why he didn't make that statement. But I know that he prepared comments that he spent a lot of time thinking about. I expected him to speak as to the victims. Sorry to interrupt.
Mr. Fry, is there anything you'd like the court to know or consider before I continue on with sentencing?
Yeah, I'm just nervous as all. I just hope that the family can express forgiveness for what I have put them through all this, and that I'm so sorry for what I did to them. It's awful. That's all I have.
Okay. Mr. Callow, do you have anything based upon that?
No, Your Honor, thank you.
Okay. Attorney Mayor, based upon that, is there anything else you'd like the court to consider?
Judge, just I appreciate you allowing him to get back in on that. He's not a speech maker, but all I can do is tell the court that I have shared quite a bit of time in my office with both my client and his wife, and he has reflected on each occasion that he's met with me about how significant he has taken this and how much he has thought about the potential for even worse consequences and injury than what did happen, and that he understands. And he does have children. He's got 2 adult age children. He's got a grandchild, and he has done the best he can to put himself in the position of those parents to think what they've been through, and also what the children themselves suffered with respect to the broken leg and the lacerated spleen. Thank you.
Thank you. The court is considering the factors with regard to recidivism. And in this case, the court does find that the recidivism factors pursuant to 2929-12D would indicate that recidivism is a concern, or more likely in this case, that specifically being that you have previously been found guilty of criminal offenses. As your attorney pointed out, your interactions with the court system or the legal system have been related to your alcohol consumption, and not just your alcohol consumption, but your decision to operate a motor vehicle after you have operated or after you've consumed alcohol. The court would note that in the pre-sentence investigation report, it would appear that you don't believe you have a problem, that alcohol is not interfering with your life apparently in other ways, and the pre-sentence report would indicate that you've never obtained or received any substance or mental health treatment, which would be consistent with your statements that seeming to not think that there is an issue. The court does note that you have had a substantial period of time and considers that between this offense and your last alcohol related adjudication or conviction, rather, the time that you came to court. The court isn't convinced that that's the last time something happened as a result of your alcohol use. The court does not believe that you take it seriously. I haven't heard that you have been in treatment since this. You've had ample time to consult with a professional in some regard to help understand your decision-making at best. If you are aware that you've got prior alcohol-related offenses, sir, you have a wonderful job, an opportunity with an employer to go back to, and you are willing to risk that over, what you want the court to believe, or what the report writer was told, a couple beers, I think is what came through in the report, then there's an issue there that about your judgment that should be examined, and you haven't taken an opportunity to do that. The court does find in committing this offense that you did commit physical harm to another persons by way of the conduct in count 1. The court does find that as of today's date, you have credit for 6 days of service or time in the Ashland County Jail, and the court will enter orders giving you credit for those 6 days plus 1 additional day for each day that you will be confined in the Ashland County Jail pending delivery to the Ohio Department of Rehabilitation and Correction for placement. With regard to sentence in this case, sir, the court is not making any findings with regard to restitution because that evidence has not been presented to the court, and therefore the court at this time cannot make those orders. In this case, with regard to count 1, the court is requiring you to pay a fine on count 1 of $5,000. With regard to count 3, the court is requiring you to pay a fine of $1,075. And the court is also further requiring you to pay the court costs. The court is finding that you have the ability to pay in the future based on your ability to be employed, and therefore the court finds that you can pay financial sanctions. Information today was that regardless of whether this court imposes a prison sanction or not, you have an opportunity to continue to be employed in your line of work through BCU Electric. So the court will make those orders. The court is going to enter orders requiring you to serve a prison sanction in this case with regard to count 1. In this case, the court is going to require you to serve a term of 18 months. The court is going to order with regard to count 3, a period of 6 months that is concurrent to the time in count 1. The court's notifying you that in addition to your prison sanction, as well as your financial sanctions, that you may be subject to a period of what is called post-release control. That is part of your sentence in this case. It is optional, and if it is so imposed, it would be for a period of up to 2 years. You are notified that if you would to violate the terms and conditions of your post-release control, so period of supervision after you have been released from prison is going to have rules and regulations that you have to follow. If you violate the terms and conditions of that post-release control, you could be sent back to prison for up to 9 months with a maximum for repeated violations equaling 50% of that minimum sentence originally imposed by the court. If you were to receive a new felony offense, you may be sent to prison for the remaining period under post-release control or 12 months, whichever is greater, plus any prison term that may be imposed for the new offense. For purposes of establishment of post-release control, the court is finding that your home county is Huron County, and therefore that you are a resident, or excuse me, yes, a resident of Huron County. The court is entering orders suspending your operator's license. The court is going to enter those orders effective 12/23/2021. With regard to count 1 in this case, the court is going to suspend your operator's license for 4 years. The court, with regard to count 3, is going to suspend your operator's license for a period of 3 years. Mr. Fry, when I looked at your finances, and I looked at it's a funny thing, these pre-sentence investigations, they talk about what your financial obligations and your mortgage, and we get some understanding of what your prior sanctions have been in the past in terms of the court sanctions. And obviously you have not had any prior prolonged period of incarceration appropriate to the offenses that you were found guilty of, but you have had some fines. Those types of things obviously weren't significant to get your attention. I am hoping that this process that you have been through is going to change your behavior. No one's charged you for not being a productive citizen. To be honest with you, in this role, the judicial system isn't worried about whether you're a productive citizen. In a way, we're worried about, are you dangerous to yourself, and are you dangerous to other people? And you're dangerous to other people. I don't care whether you have a job back at BCU or not. I'm glad you do. I'm glad that you want to contribute, but the number one way you can contribute is don't drink and drive. That has nothing to do with anything else in the legal system, or really, it's a pretty simple, straightforward goal. I'm follow your dreams, follow your heart, whatever it is, but follow the law and don't be dangerous to other people and yourself and drink and drive. That's an issue that you need to address. The court's advising you that you have the right to appeal this. You have the right to appeal any maximum sentence in this case, or to seek leave to appeal any sentence that I have entered. If you're unable to pay the cost of an appeal, you have the right to an appeal without payment. So if you're unable to obtain counsel for purposes of an appeal, counsel will be appointed to you without cost. And upon request, the court will appoint counsel for purposes of an appeal. If you're unable to pay for the cost of the documents that are necessary for appeal, the documents will be provided to you at no cost. You have the right to have a notice of appeal timely filed on your behalf in this matter, and any appeal in this matter must be filed within 30 days. So to recap for you, Mr. Fry, and also to help make sure I didn't miss anything, court is not making any restitution order because I don't have any data upon which to do it. With regard to count one in this case, the court is imposing an 18-month prison term on you, and the court is requiring you to pay a fine as well of $5,000. With regard to count three, the court is requiring you to serve 6 months in jail. Obviously, that time is going to be served concurrent to the time in count one. The fine with regard to count three is $1,075. The court is also requiring you to pay the court costs in this case, and the court is suspending your operator's license for a period of 4 years on count one, 3 years on count three, effective 12/23/2021. The court orders the pre-sentence investigation report in this matter sealed for filing. The defendant is currently at the courthouse, and he shall now be placed into custody. He's remanded to the custody of the Ashland County Sheriff for delivery to the Ohio Department of Rehabilitation and Correction for placement in a facility. The court enters orders releasing the bond. Mr. Fry, I hope you take the time to take an inventory of yourself. I don't know if you know what I do, but most of the time that I'm working as a judge, I'm working with kids and their families, and we do things a little bit differently because we're working with kids, and we take the position, and the law takes the position that kids can change, and that they can grow, that they can learn, that they can make different choices, develop new patterns in their brains and their bodies. We need them to do that for their well-being, but adults can learn too, and adults can learn new patterns. And if drinking alcohol, if you don't believe that that's interfering with your life, I'm here to tell you, it's interfering with your life because now you're going to prison. It's interfering with these people's lives. And so it's a good time to take an inventory of your decision-making and what may be driving it and how to come out and make different types of decisions that don't involve you in the legal system and don't endanger yourself and don't endanger other people, your loved ones, or other person's loved ones. Do you understand?
Yes, Your Honor, I do.
Attorney Callow, do you have any anything further?
No, Your Honor, thank you.
Attorney Mayor?
Nothing else, Your Honor. Thank you.
Thank you. Mr. Fry, you're man of the Castillo Sheriff. This hearing is concluded. We are adjourned.